3 million pages of evidence, thousands of unsealed flight logs, millions of data points, names, themes, and timelines connected. You are listening to the Epstein Files, the world's first AI-native investigation into the case that traditional journalism simply could not handle.
Welcome back to the Epstein Files. Last time, we walked through Maxwell Trial Part 2. Today, we are following Victims Compensation Fund through the documentary record so the timeline, decisions, and institutional failures are clear. As always, every document and source we reference is available at epsteinfiles.fm. So start with $125 plus distributed. That is where the paper trail becomes specific and testable.
Precisely. The objective here is a forensic review. We're looking at the Epstein Victims Compensation Program, or the EVCP, as it's often called in the filings.
Right.
And we are really analyzing the mechanics, the flow of money, the transfer assets, the legal paperwork that was used to settle these claims. I think we need a tone check right at the start.
Okay.
This is an audit. It's an audit of institutional decisions. It's an audit of financial outcomes. It is not a character study. We're just looking at the ledger.
Let's open the books then. The first thing you see, the number that just jumps off the page in document after document, is $125 million.
Over $125 million, yes. That's the headline figure for distributions.
And when we look at the estate filings, they establish what they call a voluntary restitution fund. But the timing is what matters.
The timing is everything. For an audit, it's the most critical variable. These funds, they were all released after Jeffrey Epstein's death.
So this isn't him having a change of heart.
No. This is the estate liquidating assets. The planes, the properties, the financial holdings, all of it. The documents corroborate that figure, the $125 million plus, paid out to eligible claimants. But we have to understand what that money really is.
It's not a gift.
From a forensic standpoint, it's not even close to charity. It's a calculated liquidity event. A high-efficiency liquidation mechanism.
What do you mean by that? A liquidation mechanism?
Well, think about the estate's primary fiduciary duty. Once the principal, Epstein, is dead, the executors have one job: resolve all claims to clear the assets for distribution.
You can't sell a building if someone is suing you over it.
Exactly. You can't sell a Manhattan townhouse with 20 potential lawsuits attached to the title. It's impossible. So when we see that $125 million figure, we have to view it as the cost of clearing the estate's ledger.
It's an expense?
It's a massive expense, but one that was absolutely required to unlock the rest of the capital.
I want to look at the structure of this clearing mechanism. One of the documents explicitly references a surprising historical precedent. It mentions the September 11th Victim Compensation Fund.
That is a fascinating citation to find in the record. It really is.
The
auditors, the administrators of the Epstein program, they explicitly noted that the EVCP was designed to provide, and this is a quote, similar compensation to similarly situated victims.
What does that tell us? Why model it after 9/11? That seems like a completely different category of event.
It indicates a standardized, almost actuarial approach to trauma.
Actuarial? Like an insurance company?
Precisely. The 9/11 Fund was created for a very specific reason: to prevent mass litigation that could have crippled the entire airline industry and, by extension, the economy. It created a matrix, a grid. If you lost a loved one who was a high-earning professional, you got X. If you were a first responder with a specific injury, you got Y.
It's a formula.
It's a formula. So by referencing that specific model, the Epstein program was signaling that they were not interested in individualized, drawn-out public litigation for every single claimant. They wanted a grid. They wanted speed.
They wanted to standardize the payout for sexual abuse.
In the same way the government standardized payouts for wrongful death or injury on 9/11.
Yes, which removes the variability of a jury trial.
It removes the variability, and crucially, it removes the publicity of a jury trial.
That's a huge point.
A jury trial creates a public transcript,
Well.
discovery, depositions, a compensation fund. It just creates a receipt.
So let's dig into the transactional nature of this. You said it wasn't charity. The documents make that incredibly clear.
They do. The text is unambiguous. Payments were made in exchange for ending liability. This is the core transaction. The estate buys peace. The claimant gets liquidity, they get it SAS'd, and they get it privately.
So the product the estate bought for that $125 million?
Was the releases.
Yeah.
The signed legal documents that said, we are done. Full stop.
Which brings up the word voluntary that we saw earlier, the Voluntary Restitution Fund. How voluntary was this really when you consider the pressure on the assets?
It's voluntary in a very narrow legal sense. The estate was not yet under a specific court order to pay out that exact amount to those specific people, but practically, it was necessary.
A forced move.
Absolutely. The executors, and we see their names in the filings, they were managing an estate that was under siege. You have to consider the burn rate.
The legal fees.
The legal fees, maintaining the property, securing the art, the planes. If they hadn't created this fund, the estate would have been bled dry by dozens of individual lawsuits, each with its own team of lawyers. The $125 million was an investment in stopping the bleeding.
So let's unpack how that transaction actually happened on the ground. The operational mechanics. How did it work? There's a document, the Epstein Victims Compensation Program protocol.
Right. The protocol was the governing constitution of the entire fund. It laid out a very clear four-step process.
Okay, what were the steps?
First, a claimant had to submit a claim form. It was often referred to as a questionnaire.
So you fill out paperwork.
A lot of paperwork.
Yeah.
Second, that claim went to an independent review by the administrator. Third, the administrator would make a determination of eligibility and then calculate an award amount based on their internal matrix.
And the fourth step?
The execution of a release. If you wanted the money, you had to sign on the dotted line.
I want to focus on that phrase, independent review. The documents describe it as an independent program designed to compensate and resolve the claims. But was it truly independent?
That's the central tension you see woven through all of the files. Operationally, you could argue yes. The administrator, in this case it was Jordana Feldman, she had the autonomy to look at a claim and say, this is credible or this is not.
She can make the judgment call.
She could. However, the funding source, the money itself, came from the estate. The estate is the entity writing the checks.
So she's not really independent if her budget comes from the people she's judging claims against.
It's a conflict of interest, structurally. While the administrator determines who gets paid and how much, the very existence of the fund relies entirely on the estate's willingness and ability to liquidate assets to fill the pot.
So there's this tension between the administrator's autonomy and the estate's need for finality.
A constant tension. The administrator works for the program, but the program exists to clean up the estate's liabilities. It's a symbiotic relationship.
The administrator needs the estate's money to pay the victims.
And the estate needs the administrator to sign releases to sell the properties and close the books. It's a feedback loop. And if the estate suddenly runs out of liquidity, say they can't sell the Zorro Ranch or the Paris apartment, the fund just stalls.
So the independence is operational, but the dependency is entirely financial.
That's a perfect way to put it.
There's a document that highlights what you called, I think, the one-way street.
Ah, yes. This is a crucial procedural detail. Participation was voluntary. No one was legally forced to enter the program. They could still choose to sue in open court.
What?
But it was binding upon acceptance. The record references a compensation offer. If a claimant got that offer and accepted it, they were required by contract to dismiss any and all pending litigation against the estate.
You couldn't take the money and then keep suing?
No. It was an either proposition, a fork in the road.
And that forces a huge strategic decision for the victim and their lawyers.
It forces a risk assessment, a brutal one. Do I take this guaranteed amount right now, determined by this private secret matrix? Or do I roll the dice in federal court, knowing it might take 5, 6, 7 years, and I might get nothing in the end if the estate runs out of money before my case gets to the front of the line?
The program leveraged time.
It weaponized time. It offered speed and certainty in exchange for a hard cap on liability.
Which brings us to the next logical question. Who qualified? Who is actually invited to make this either choice? The documents seem to define the term victim.
They do. The primary qualification was, of course, being a survivor of sexual abuse by Epstein. But the documents show a very specific focus on minor victims.
We see that term everywhere. Minor victim 1, minor victim 2.
Exactly. And the geographic scope is also important here. The documents are cross-referencing activities and victims from New York, from Florida, from the Virgin Islands, New Mexico. This wasn't limited to a single jurisdiction.
So why the specific designation? Minor victim. What's the significance of that from an audit perspective?
It's all about liability and the statutes of limitations. A minor victim has a much longer window to bring a lawsuit. And more importantly, their damages calculation is different.
Different how?
Actuarially. The calculation for loss of enjoyment of life or loss of future earnings is exponentially higher for a 14-year-old than it is for a 24-year-old. The timeline of damage is longer.
So when the administrator is building that compensation grid we talked about,
Okay,
the one based on the 9/11 model,
age is a multiplier, a huge one. The estate knew that claims involving minors carried the highest potential financial liability in open court. Resolving those specific claims was, therefore, the absolute top priority.
there's a very specific and I'd say disturbing element to the eligibility that comes up in the audit, a file that details the recruitment process.
Yes, this is what I'd call the recruitment audit. The files contain stark evidence of the internal economy of the trafficking ring. There's a document that explicitly states, and I'm quoting, he paid these victim recruiters hundreds of dollars for each girl.
So you have a situation where a victim is also technically on the payroll.
Which, from a forensic accounting perspective, creates an incredibly complex eligibility classification. You have individuals who possess what you could call a dual status
They're both a victim of abuse.
and a recipient of payments for recruitment. The compensation program had to navigate this minefield, and the audit trail shows that they generally did not disqualify victims based on what was clearly coerced participation in the scheme.
They saw the recruitment as part of the abuse.
They recognized it was part of the mechanism of control, part of the grooming. But financially, it complicates the victim profile immensely because you have a record of outgoing checks from Epstein or his entities to these women years before the compensation fund even existed.
So the administrator had to distinguish between, wages for recruitment and compensation for trauma.
Correct. And that is a very, very nuanced forensic accounting challenge. Imagine you're the administrator. You're looking at a check register from 2005. You see a payment for $200 to a young woman. Was that a gift? Was it for a massage, as was often claimed? Or was it a recruitment fee?
How could they possibly know?
Through the totality of the evidence provided in the questionnaire, the narrative. By paying these claims, the program was effectively making a ruling. They were ruling that those prior payments were evidence of the crime, not evidence of employment.
And in doing so, they essentially set aside a major legal defense the estate could have used.
The huge one, the unclean hands doctrine.
Explain that.
In civil litigation, it's a defense. It basically says if you participated in the illicit activity, you can't then turn around and sue for damages from that same activity. The estate's lawyers could have tried to argue that in court. They could have said, she brought us other girls, she was a co-conspirator, she has unclean hands.
If they didn't.
By creating the fund and paying these specific claims, they waived that defense. It was an institutional admission, even if it was made for purely financial reasons, that the power dynamic made that recruitment involuntary. That's a significant finding in the documents.
So to get that compensation, a victim had to prove their case. The documents talk about corroboration.
Yes, claimants had to provide specific and testable accounts. That phrasing is very deliberate.
It's different from a criminal trial.
Very different. In a criminal trial, the standard is proof beyond a reasonable doubt. The program, based on the speed of the payouts and the sheer number of claims processed, almost certainly used a preponderance of the evidence standard.
Meaning it is more likely than not that this happened.
Exactly. It's a much lower bar, which allows for faster processing. But the key phrase is specific and testable. That implies they weren't just taking someone's word for it. They wanted dates, locations, names, descriptions, details that could be cross-referenced against a master record.
Consistency was the currency.
Consistency and the ability to be tested. The word testable implies they were testing these claims against something.
Against what?
Against the estate's own internal records. The flight logs for the jets, the infamous little black books, the household staff schedules from the various properties.
So if a claimant said, I was at the Palm Beach house in July of 2002 and Ghislaine Maxwell was there,
The administrator could, in theory, pull the logs, pull the staff records. If those records showed Maxwell was in London that entire month, the claim would fail the test. It suggests the administrator had access to a master database of the Epstein organization's movements that the public and even law enforcement may not have had in its entirety.
Okay, we've established the money, the mechanism, and the people who qualified. Now we have to look at the other side of the ledger. What did the victims give up? We've touched on the releases, but one document goes into incredible detail about the sheer scope of them.
This is the most critical part of the audit. The central question is, and always was, who was protected when a victim accepted a check? The document discusses providing a defense as to any victim whose identity. And then it gets into this very broad legal language.
And it wasn't just, I agree not to sue the estate of Jeffrey Epstein. It was much wider than that.
Oh, much, much wider. The audit finding here is significant. By accepting compensation, victims often release not just the estate, but potentially also, quote, employees, agents, and affiliates.
Affiliates. That is a term that could mean almost anyone.
It is an incredibly broad and legally powerful term. It's effectively an immunization strategy for the entire network.
So if you're an associate of Epstein's and you fall under that vague definition of an agent or affiliate, and a victim signs this release to get their compensation,
You are potentially shielded from any future civil liability regarding that specific victim's claim. The program settles the claim against the estate, but the legal protection radiates outward. It clears the board for a much broader network of people.
let's make that concrete. If I am a pilot who flew the plane on which abuse occurred, and a victim who was abused on my flight signs this release, can she later sue me individually?
It becomes extremely difficult. Your defense attorney would immediately produce the signed release from the EVCP. They would argue that as the pilot, you were an agent or employee of the estate, and therefore the claim against you has already been settled and released.
The release acts as a firewall.
A comprehensive legal firewall. The victim got paid by the estate, but the protection extends to the entire staff, the entire infrastructure that enabled the abuse.
And we see the human cost of this transaction in some of the transcripts. There are records showing survivors saying things like, I was the perfect victim, and expressing a desperate desire to just stop having to relive the trauma.
This really highlights the inherent limitation of a purely financial program. The EVCP provided monetary redress. It did not and could not offer restorative justice.
There was no public apology.
No truth commissions. No opportunity to confront the enablers in a courtroom. The document captures that tension perfectly. The money provides a form of relief, a way to, as they said, stop reliving the financial stress or the legal battle, but it doesn't solve the underlying institutional failure or provide psychological closure.
That phrase, I was the perfect victim, it suggests a performance, that they had to fit a role.
It suggests they understood the matrix. To maximize their reward from the fund, they understood they had to fit the profile of severity that the administrator had established. They had to narrate their abuse in a way that would trigger the higher payout tiers on that secret spreadsheet.
And what a psychological burden that must be, tailoring your trauma to fit an actuarial table.
It's the cost of entry into the program.
The documents frame all of this explicitly as an alternative to litigation. One file even references a headline, Epstein ducks victim testimony.
And that's the trade-off, isn't it? The program removed all of these cases from the public court docket. For the victims, yes, that provided privacy and speed. Those are benefits that we should not understate. Litigation is a brutal, public, and years-long process.
For the estate.
And for the public interest, it prevented the public airing of evidence. Institutional memory relies on public records, on trial transcripts, on depositions. When you settle these cases privately, you create a black hole in the historical record.
The Epstein ducks victim testimony headline reflects that loss of public scrutiny.
We didn't get the depositions of the pilots. We didn't get the discovery requests for the financial records of his associates. That entire process was short-circuited by this fund.
We have to talk about the government's role in all this. Before the fund, the Department of Justice. Some of the documents trace the entry of victims into the DOJ's own victim notification system, the VNS.
Right. And there's a recorded discrepancy here, a major one. The audit trail shows significant friction regarding when victims were officially notified versus when the now infamous non-prosecution agreement, the NPA, was actually signed.
And there's a law about this, isn't there? A document references the Crime Victims' Rights Act, or CVRA.
The CVRA. It guarantees victims the right to, and this is key, confer with the attorney for the government. The documents strongly suggest there were systematic failures in providing that timely notification.
So victims are being entered into the official notification system.
After the key decisions about the NPA had arguably already been made behind closed doors, this suggests that the institutional machinery of the Department of Justice was completely out of sync with the rights of the victims it was legally mandated to protect.
The phrase right to confer implies a dialogue, a conversation before the deal is done.
It absolutely does. If you're only notified after the signature is already on the page, you aren't conferring. You're being informed of a decision that's already been made about you, without you. The timeline in the documents shows a critical lag. The deal, the NPA, was cut in secret. The official notification came later, and that lag effectively disenfranchised the victims from the judicial process until it was far too late to intervene.
And this leads directly to a crucial pivot we see in the legal filings, the distinction between restitution and compensation.
This is a legal pivot caused entirely by mortality. Restitution is a specific legal term. It is court-ordered as part of a sentence in a criminal case.
So if Epstein had lived and been convicted,
The court would have ordered criminal restitution. But because he died in custody, the criminal case against him was dismissed. The legal term is abated by death.
so criminal restitution became legally impossible.
Correct. And in that moment, the Civil Compensation Program, the EVCP, became the only vehicle left for any kind of financial recovery. It wasn't just a convenient alternative anymore. It was the forced institutional pivot, the only game in town.
Yeah.
The victims went from being witnesses in a federal criminal case to being creditors in a private estate administration.
That's a fundamental shift in status and power.
A complete inversion.
So let's look at the gaps. An audit is as much about what's missing as what's there. One document vaguely references various transfers of funds.
Right. And this is a major gap. We know, with a high degree of certainty, that over $125 million went out of the fund. The documents in the public record are much less transparent about the specific inflow origins immediately prior to the fund's creation.
So the paper trail on the deposits, it fades.
It goes cold. Did these funds come from complex offshore trusts in the Virgin Islands? Were they repatriated specifically to pay these claims? Or was it just the straightforward liquidation of his domestic stocks and real estate? The phrase various transfers of funds is intentionally vague. From a forensic standpoint, you want to see the wiring instructions. You want to know the provenance of the cash. The documents don't give us that.
And then there are the people. Another document contains handwritten notes, redactions. It mentions specifically Maxwell's handwriting with the name of another victim.
This points to the persistent pattern of the unknown co-conspirators. The compensation program, remember, only settled claims against the estate. But the documents are littered with the names and actions of others, recruiters, schedulers, pilots, house managers, who all remain in a kind of legal gray area.
The program didn't adjudicate their guilt.
Not at all. It paid out for the estate's liability and the estate's liability alone. So there's this massive gap in the forensic record regarding the specific financial and legal liability of these dozens of third parties.
But the document mentioning Maxwell's handwriting, that directly links her to the administration, the logistics of the Victims.
It links her to the operational logistics, yes.
Yeah.
The fact that her handwriting is on a document that also contains the name of a victim who is now seeking compensation, it creates a direct line of sight. But again, the compensation program wasn't a trial for Ghislaine Maxwell. It was a settlement vehicle for the Epstein estate. So while that piece of evidence is sitting there in the file, the program itself didn't issue a verdict on her role. It just cut a check to the victim to settle the claim against Epstein.
Finally, there's the question of the rejection rate. One filing mentions the process of determining the credibility of a victim's claims, which implies some claims were found not to be credible.
And in any mass tort program like this, it's a certainty that not every single claim submitted was validated and paid. But the rejection rate, and more importantly, the criteria for deeming a claim ineligible, that all remains a sealed metric. It is not in the provided document.
So we don't know how many people were turned away.
We have no idea. Was it 10, 100, 1,000? And we don't know why. Was it because they lacked that testable corroboration we talked about? Was it because their timeline didn't match the flight logs? Those rejected claims are the dark matter of this audit. They represent the stories that were told but were not, for whatever reason, purchased by the estate.
So if we have to synthesize all of this, what is the final forensic conclusion?
The Epstein Victims Compensation Program functioned as a high-efficiency liquidation mechanism for a compromised estate. That's the cold, hard truth of it.
It did succeed in one thing.
It did. It successfully distributed a significant amount of capital, over $125 million, to survivors without the agonizing delay of litigation. In terms of just moving money to people who deserved it, that is a verifiable success. However, from an audit perspective, it also functioned as a silencer. It converted public legal claims into private financial settlements. And in doing so, it effectively closed the books on the estate's direct liability while leaving the broader network of affiliates and enablers largely unexamined and untouched by the civil court process.
The release was the asset.
The documents prove it. The release was the single most valuable asset the estate purchased with that money. It bought finality, it cleared the titles on the real estate, It stopped the lawsuits cold.
So, to sum up, we have documented the flow of over $125 million. We've seen the administrative protocols that categorize human trauma into payment tiers, and we've traced the institutional shift from criminal restitution to private compensation after Epstein's death. The paper trail confirms the payouts, but the releases signed in exchange have sealed off countless potential avenues of discovery regarding third parties.
The ledger is balanced, but the account is not closed.
Next time, civil lawsuits.
You have just heard an analysis of the official record. Every claim, name, and date mentioned in this episode is backed by primary source documents. You can view the original files for yourself at epsteinfiles.fm. If you value this data-first approach to journalism, please leave a 5-star review wherever you're listening right now. It helps keep this investigation visible. We'll see you in the next file.